Hi, and welcome everyone to this CITI Network event on intellectual property and commercialisation. I'm Sarah Williams. I'm a GP by background, recently joined CITI as a clinical fellow in innovation to Nadine Hichacha-Ram, who's a Director of Innovation and Partnerships here. Just for a quick intro into CITI, it's a Centre for Improvement, Transformation and Innovation here at GSTT, headed up by Lawrence Tallon, the Deputy CEO. Some of you will know us already, and some will have joined for a previous series on artificial intelligence. So welcome back to those who've been here before. And for those who are joining for the first time, we're really excited to connect with you, to have you here, and it's great to see you here with us. You can find that previous series on YouTube, and we're going to be having regular events. The summer lineup is already confirmed, so thanks for joining today, and I really hope you enjoy it, find it useful, and put the dates in your diary for the next ones. Since starting a CITI, I've been super excited to see the progress we're making to facilitate change in the trust. One of the ways that we want to do that is through developing a network of change makers, people like you all who are passionate about making things better for our patients. So today's event is as much about us getting to know you, and we hope these events will inspire you, enable you, and connect you with the right people who can help you in your journey from making your ideas that you have into reality. We know there are so many of our staff who have excellent insight, amazing insight into ways we can improve care for our patients, whether that's through improvements to existing care, change in service, or a new idea for a product. We don't want those ideas to get lost because people don't know where to go with them. So we want to empower you and help you navigate through any of those barriers. We also know, and I can speak from experience, that sometimes it can feel a bit isolating to be pushing for change alone. And so we want this to be a platform for you all to be able to connect with other people who care and who you can join forces with, share ideas with, and work with. We also want to be providing some skills and knowledge, and we've got a whole host of experts here in GSTT to call on. So today's topic is IP and commercialisation, and that's been a real eye-opener for me as a clinician. I hadn't really appreciated the importance of it previously, but now I can see that a grasp of it, a basic knowledge of it, it's really invaluable for innovation. And actually, I'd love to see it more widely publicised to healthcare staff. I think we'd all benefit from knowing more about it. So understanding IP and commercial routes, as you're going to be hearing early on in your idea, will save a lot of backtracking further down the line and give that solid platform for your venture, make it much more likely and smooth for you to succeed in making the most with your idea. So I'm not the expert on it, certainly not. I'm really glad to have people here at GSTT who are. And just quickly before I pass to Tas, I just want to encourage you that this network is all about the opportunity to connect. So please do look at our website and contact us as well. And from here, I'll pass on to Tas. Thank you.
Thank you very much, Sarah. Thank you very much for that introduction. And thanks a lot for everybody who has joined the seminar today. And we hope you find it very useful. We have two other people on the seminar today, and I'll briefly introduce them, and they'll speak a bit later on. Didi is on the call, who is, as many of you know, he is the Chief Biomedical Engineer within the Trust, and also Debra Guest, who is based within CITI as one of the innovation consultants. Both will be joining the discussion with regard to IP and commercialisation. And before I bring them into the conversation, I just wanted to go through my take on IP and the context and the importance of IP within the environment in which we live. So I'll bring up my slides, and it won't take too long to go through them, and then it will be a more conversational discussion with Didi and Deb's involved as well. So I'll share my slides to start. Okay. Yeah. Okay. You should. Okay, I should all be able to see that. I'll say a little bit about myself just in terms of my own background before going into the IP. I come from biomedical background, by biomedical sciences and biotechnology. Following that, I did work in industry within business development and sales roles within the life sciences industry. And within those roles, I worked with client organisations all the way from universities to big pharma. So in terms of sales with regard to consumables to big manufacturing equipment. My work with universities at the time brought me into contact with technology transfer offices, and I became quite interested in the commercialisation of intellectual property in terms of developing products which are going to benefit patients for commercial purposes, etc. And at that point I moved into to work within the university tech transfer environment, and also within NHS Innovations at the time, and developed my career along the path. And currently I am the senior IP and commercial research manager within GSTT. So that's very briefly my own background, just to let you know in terms of where I come from and my knowledge base. Quick agenda. I want to give a brief introduction to commercial innovations teams who now sits within CITI, a very broad overview of types of IP. And it will be a broad overview this time because we are planning to have two other seminars as part of this series, which will cover patents very specifically and other types of IP in more detail. But what I would like to cover within the context of this seminar is the context of IP management, its relevance and importance. And I will cover both strategic and practical considerations around IP. I will then bring in Didi in terms of as a view from an innovator. I have worked, both Debra and myself have worked with him in terms of a number of innovations, and we have recently patented a novel idea which we were taking through to commercialization. And Debra too will then talk about some GSTT specific products, which I think would be interesting to you to hear about and how they developed and came about. So just on the commercial innovations teams, that this the team did until the beginning of this year sit within the commercial directorate, but is now part of CITI. And one of the things I would like to say about it is it has a unique selling point. It is one of the CI team within GUISE is one of very few technology transfer offices within an NHS trust, and that is relatively unique and something which is admired by the trust in terms of us having that expertise. The team's made up of Siobhan, who focuses on health data innovation, Eucrit, who's focused on life sciences. He's a life sciences innovation manager. Maricela, who's currently on maternity leave, is another IP and commercial research manager, and myself. And the team is managed by Adam Agri as it currently stands. Now, the main activities of the team fall into these three categories shown on the slide. One is IP commercialization through licensing and spin-out activities. We also manage IP arrangements of our research contracts, and this is particularly important when it comes to major translational research programs, particularly ones we may have with for example, KCL, where the trust's IP position does need to be protected. It may be multi-party contracts. I mean, I've worked in the past in contracts with over 20 partners, and the IP position of the organisation does need to be protected. And I stress the importance of KCL as an important strategic partner with us, and we have a number of translational programs with them. And And within the context of those programs, there are often quite a lot of discussions around IP and how that is best managed for the benefit of both organisations. So I hope that gives you an overview of what we do within the commercial innovations team. I said I would touch very briefly on IP, on what is IP, and come back to more details in later seminars. One definition of IP that I use, it is the product of your intellectual endeavour. There are more complex ones, but I think that's simple and catches the essence of what it is. It's a protectable asset which can have commercial value, well, via licensing and spin-out creation. And I've put their background and foreground IP. For those who are not aware, I think it's useful to know what they mean in the context of any particular project. So background IP is the IP that exists before the project is started, and the foreground IP is the IP that's created as part of new IP as part of the project. And often that is where the discussions are around how that is best managed. I also wanted to just emphasize or explain the difference between terms inventive and non-inventive contributions. Inventive contributions are those that are made creatively, intellectual thinking. That is where the intellectual endeavour comes in, and those relate to who owns the IP. But very importantly, within the context of an NHS organisation, we do make a lot of non-inventive contributions, such as providing patient samples or data, and they have a lot of value. And often, in my experience, they can be undervalued, those non-inventive contributions. And for that reason, I think it's really important to sort of understand what they are and what the total contribution of an NHS organisation in a project would be. And then I've just listed the types of IP, how IP can be protected. Most people, when IP is mentioned, they think of patents, and patents are around technical innovations. So they look at the novelty and inventiveness of a new idea. Novelty being whether it's been cited or discussed in the past, if it's present in the current literature, for example. And inventiveness is really all about whether the invention it was obvious for the average person working in the field. So those are the two criteria that you assess when looking at patents, and that's a topic that we will come back to in the next webinar. Copyright is all about originality of things. Trademark is about distinctiveness and marking and trademarking. Trademarks are all about distinctiveness and branding, which is what I meant to say. Design rights, database rights, and trade secrets and know-how are also all forms of IP, and particularly in the context of a clinical academic environment, trades, know-how is particularly important as well. But we'll come back to all of these in more detail in subsequent seminars. Okay. So look, just moving on to some of the strategic considerations around IP. Why is IP important, and why should, what's the relevance of that in your work? If you're asking those questions, I just want to go through, based on my experience, some of the things which are important overall around this and setting the context. So international trade increasingly is dependent on knowledge economy and the ownership of intellectual assets. It could be said that was probably true at all times in human history, and no doubt there is truth in that. But I think the general consensus is these days that there's such a rapid rate of knowledge development. We've never seen anything like it before, and so IP becomes relevant. We only have to think of developments in AI to appreciate the rapid rise in which the knowledge economy is developing. And thinking of AI, data-driven activity is a key CITI strategy So that's probably also worth mentioning. The third point, very importantly, global problems are too complex for any one organisation these days. I think there's a general recognition for any one organisation to come up with the solutions for the global problems we face today. You know, everything from global warming to how to make healthcare sustainable. All these issues makes the problems extremely complex, and therefore there is a need for co-development and collaboration models where organisations with synergistic knowledge and assets come together to find solutions to problems. And therefore, you know, in developing these collaborations, it is important once again to protect the trust IP position. Partnership and collaboration is also an important CITI strategy, and that would also means managing the ownership of our assets, IP assets, and in protecting those assets, what I would say is that we have to also be thinking of the benefits. Ownership is important in its own right sometimes, but often we have to make a compromise and think also about the benefits. It's the access to the IP that we really need, and it's a balance about whether we need ownership and whether we need access in those partnerships. Those are key decisions to be made as we sort of develop the collaboration and bring those agreements together. The emergence of open innovation, which most often operates at the pre-competitive stage. That is emerging in industry where they do want to have more open relationships with academic institutions and clinical organisations, but they do operate at the pre-competitive stage, and it's still, because they are pre-competitive mostly, it is important still to think about IP and how best that is managed if a project does take hold and develop further from those discussions. I would also say that whether you want to protect the IP, it is important in many situations. It does also depend on the commercial strategy that you wish to follow, and it's often a balance between the cost of protecting the IP, because patents can be very expensive, and the returns that you get from that. So it's making that judgment whether the investment in protecting the IP justify the returns. But what I would say is that usually for most biomedical innovations, because the market size is usually very big, or certainly big enough in most cases, protection is often justified, protection of the IP rather than not. Although we do have examples where we have commercialized and not protected, and Debra will talk about an example of that. So what I would also emphasize is that unless something is protected, if it's important to protect it, it is best to protect it, because if we don't, then we lose the ability to develop the idea ourselves. It will be most likely picked up by other people, and we will not get the recognition for the initial work that we might have done, because it has been picked up and developed by other people. And IP protection can be needed for both commercial and non-commercial applications. So if you are going to protect something, obviously if it has commercial value, it's important to protect it, sufficient commercial value. But I've also been involved in projects where we decided to protect something where the market size wasn't particularly big, but I was working in university at the time, and we decided that the impact of owning the IP and showing it to be a university or innovation was important from an impact point of view. And when we did go down through the route of protecting it in that situation. Okay, so it is a balance of it, whether it's a commercial opportunity or not, deciding what is important for you, and protecting on a case-by-case basis. There are also strategic considerations with regards to the NHS itself. The NHS is an important component of the UK and international innovation ecosystem, mainly because it adds value to the translational research about how it happens, and its ability to provide the clinical trials which result in commercial products. So we are central to UK competitiveness in health innovation, primarily due to providing the clinical trials and then hence the ability for those products to be adopted by the relevant client organisations going forward. And one area where that is really important, I think, from a competitive point of view, worth mentioning, is cell and gene therapy, where currently we are a little bit behind the US. We are considered world leaders in cell and gene therapy. And one of the reasons, one of the things that will keep us leaders, I believe, is that if organisations, NHS organisations, do enable greater adoption of new products in the cell and gene therapy area, that will attract more companies to the UK. But if that adoption isn't facilitated because the clinical trials, aren't optimally operating, then that could have a knock-on effect on that particular industry, for example. I'm just using that as an example. But the NHS's ability to allow clinical trials and hence the adoption of products is a really key driver of its value. The NHS also provides samples, patients, clinical data, genomic data, which has great value, without which many innovations, especially in the AI space, just wouldn't happen. They're often undervalued because they're considered non-inventive, but I think there's a discussion around about the value of that sort of those sorts of inputs that we have in any commercial products. The sustainability of the NHS itself, I think, is also important. Now, innovation generally and how the NHS is sustained going forward, I think there is a limit to how much monetary resources can go into the NHS to keep it viable. And once that limit is reached, then you also have to have innovations of how the NHS works, how we deliver that value to patients, how we deliver that benefit to patients. Now that is innovation overall, and part of that, there is a role for IP-driven innovation as part of that. And one of the reasons I say that IP-driven innovation is important is because if the IP is protected by an NHS organisation like GSTT, then we can be a driver of healthcare delivery innovations globally, and especially in our partnerships with KCL. I mean, it's a partnership where we're well positioned to be world leaders in healthcare innovation. So I think owning IP when it's appropriate, it is important as well for that reason, because we can operate in a way which affects innovation globally in healthcare. Just a couple more slides. I think there's a few things to be said around strategic considerations and when working with industry. Now, commercial organisations can be very aggressive in their ownership of IP, and in having our negotiations, we need to protect our position. Not only in terms of wanting, if we need to own the IP in terms of owning the IP, but also to ensure that we are compliant with NHS rules and regulations in terms of how patient data and information, etc., is handled. As a general rule, I would say that companies do push to own IP and often say that they need it for their commercialization efforts. But on the whole, as a general rule, ownership of foreground IP, new IP that's created by the trust, ownership by the trust is generally fine. As long as we give a commercial license to the company, that is generally sufficient for them to do whatever commercially that they want to do. The only time I would say that a commercial company most definitely may need to own the IP, and they may have a good argument for it, is when they're raising venture funds or funds of other sorts, and it's important for them for that reason. But that doesn't automatically mean we allow them to own the IP. It's a consideration, and that they will push harder for owning the IP if they are raising funds, for example, venture funds. The other point I would say in terms of IP, if we're creating spin-outs, standard practice is to license the IP to the spin-out company. no, there's no need to assign that at the beginning. Generally, there may be a case for it on an individual basis, but consider assigning the IP to the spin-out company when it's raising venture funds, significant venture funds. So that I thought those would just be some general rules or considerations to highlight. Okay. The next couple of slides are really just a few practical considerations if you're an inventor with a new idea, things just to bear in mind in terms of properly managing that IP. Important to keep all new ideas confidential and speak to the right IP person, you know, within the organisation, and because otherwise, if you do disclose, whether that's by publication or even verbally to colleagues or especially those outside the organisation, that protection would have been lost. Your ability to protect would have been lost because it will be disclosed. It would be considered this idea would have been considered disclosed that largely lost forever. Use confidentiality agreements if you do need to have conversations with external parties. But I would also say that even under an NDA, even under confidentiality agreements, only give the minimum information to the other party that they need to know to make the relevant decisions. Also use MTAs if you're transferring materials to and fro. Again, that will help the management of those materials and IP considerations. And the other point I would emphasise, and this just does come up a lot in collaborations, is there's often talk of joint IP. Now, joint IP, there may be a case for joint IP in certain situations, and that is fine. Those conversations can be had. But there are considerations, there are downsides to joint IP. One of which is it's administrative. To commercialize, if you are going to commercialize that IP, it becomes an administrative burden to get both parties to agree to things, so that can slow the process down. But perhaps more importantly, joint IP is managed differently, or can be managed differently in different countries around the world. So, for example, in some countries, if IP is jointly owned, then each party can go into whatever they like with that IP without any permissions from the other party. So it's a complex situation to think about, not always as straightforward as people might think if a joint IP is proposed. That's not to say there isn't a place for it. It is something that needs to be discussed. If the other party is owning the IP that's arising in the project, I would, in that situation, it's also very important for us to have a license back for research and teaching in those sort of situations. And my last point is something I've repeated already. We can own the IP and give a commercial license on that. The company doesn't always have to own it. This is one of the final slides. Just some general rules to remember. IP created by an employee is generally owned by the employee if it relates to their work, and there is an IP policy in place which enables revenue sharing because of that ownership going to the employer. Also remember, if students were involved in a project, the students are considered independent and own their own IP, and so agreements need to be put in place with the student before they start any work that any IP they generate is owned by the trust, for example. And the same applies to contractors and consultants. Unless we agree beforehand, they will own the IP that they create, and which will obviously cause problems later on if they don't assign it to the trust. Be aware if the project has been funded by a research council, understand all the terms and conditions attached to that, especially around IP ownership and permissions to commercialize. And if companies own the IP, as briefly said before, we need a non-commercial license back for at least for teaching and research. And the very last point there, if you're ever asked to give written or verbal warranties on IP, I wouldn't give those. They can be risky. Largely leave any due diligence work on IP to the licensee to do. Okay. And this is the very last slide. I've just put this up to just depict the process that we go through when we're commercializing any piece of technology. We undertake an IP evaluation, which evaluates the relative strength of the IP. Assuming that that's positive, we then will look at a technology appraisal, which analyzes the readiness of that technology for the market, and therefore will give us an idea of how much funding it needs in the future to get it to market. We'll undertake a market analysis, whether about the suitability of that proposition for that particular niche market, and then business planning, how we're going to exploit this IP, and commercialization planning to maximize the revenue and profit. And although I've listed those as bullet points, quite often that's not always a sequence. Some of those things happen in parallel to inevitably. Okay, that's the end of sort of my take on some of the strategic issues, and I would like to bring in Didi into the conversation. Didi, if you could just briefly give an overview in terms of introduction to yourself again, and a little bit of information about the idea that you're currently working on as well, please.
Brilliant. Thanks a lot, Tas, and thank you. We did sort of start to discuss a few talking points beforehand, and hopefully now you can see my screen. So first of all, who am I? Thanks for the introduction, Tas. I am the head of clinical engineering, the chief biomedical engineer. And what that really means, me and my team, it's about how we make the most of technology in the trust, and it's not necessarily just inventing stuff. In fact, it's broadly more about how we use it, how we invest in it, how we maintain and support it, and how we optimize all those systems around that. But of course, my interest ultimately is in how we get the most out of technology, and it sort of leans into the kind of inventor agenda. I've been at the trust for over 10 years now, and what I'll say is that the story that I've had is kind of it predates that in terms of its start, but experience so far with CITI has been very positive and encouraging. I say apart from all the support in terms of IP, which from what Tas is saying is clearly needed because it's so complex, but it's also the encouragement and a little bit of permission to innovate as well. So I'll say that up top. Also up top, I should apologise for my haggard appearance and probably haggard delivery because of the household. We've got a bit of COVID running rampant, and you might also hear some little ones in the background. So sorry about that in advance. So in terms of this invention, really starting with the problem, chemotherapy-induced peripheral neuropathy. And you'll guess from my title that I'm not an oncologist. I'm not a specialist in cancer services in particular, but in our team and in many other teams, this is recognised as an urgent unmet clinical need. And what do I mean by it? So during chemotherapy, this is one of the most acute and debilitating side effects that happen, and actually it's also very common. What happens is the drugs used in chemotherapy are deposited in the extremities, your hands, or feet, in the hair follicles, where they're not intended to be used often. And what that happens is they do their business of damaging tissue, and in doing so they can damage nerve, they can cause pain, they can cause loss of function. And this can have quality of life implications, especially if it's retained after chemotherapy. So surviving cancer isn't the end of the story. There's also managing some of these side effects for many people. And this is a recognised need. This isn't this won't be news to everyone on the call, perhaps, but it's understood that the current solutions to avoid this and to kind of alleviate this effect are not well tolerated, and there's room for improvement. And I guess the background to this particular invention is that the medical physics departments in the trust for some time has been looking into ways to solve this. How can we transform chemotherapy in both its outcomes and its experience by reducing treatment attrition and to improve health. And when I say treatment attrition, what I mean is not only does it cause negative outcomes after chemotherapy, during chemotherapy, that pain can cause people to drop out or for their dosage to be reduced. And this is extremely damaging because some people inevitably will not have the intensity of chemo that they would have, and therefore it's possible that their cancer isn't being cured because of this effect. So generally, we're not going to loads of the science. I've explained a little bit of it, but the assumptions that are out there in the world is that if you reduce the blood flow in your hands, in the feet, for example, during chemotherapy, you can stop the drug having that effect during the session. And so generally it's about how do we cool and how do we compress the hands, and then we constrict the blood vessels, therefore, and we minimize this drug deposition. And currently, what does that actually look like? Actually looks like the bottom left picture more often than not, where you've got these gel gloves, pop them into a freezer intermittently and bring them out, and there's little control over that. It's cold. It's difficult to manage because then you have to manage the, putting things into and out of a freezer the whole time for quite a large patient caseload. Your hands are restricted. In fact, both of these and the solutions in the pictures, including top left one, in many of these situations, they're no longer able to read a book, use their phone if they're using these. In some cases, they can be expensive. In some cases, they're too cold. They can cause frostbite and other sources of pain. And so at times it can go that way too. So the overall message is we can do better, and we set out to do that. Now, I won't go into how we arrived at this beforehand just yet, but the idea was actually, instead of pressure, instead of cooling, can we use stimulation? As an engineer, I know there's some signaling going on also from anatomy and physiology as a clinical scientist. Could we cut out the middleman and actually tell the hands to constrict those blood vessels? Can we do it in a way that wouldn't restrict hand movement? It would be silent, it would be affordable, it would be lightweight. And so there was a very specific kind of disruptive question that we wanted to answer. And of course, being good scientists, we went first to the literature, and I'm not going to talk through these papers. I'm just going to say that generally the people focus on reducing the pain. What we're talking about here is a preventive technology, and so electrical stimulation generally increases blood flow, and that's the opposite of what we wanted. But there is evidence in some old studies that actually you can see the opposite effect under certain circumstances. There's a bit of a precedent. I found this paper from 1986 where, for some reason, these scientists in Sweden were looking at electric fields and seeing if they could reduce blood flow, and seeing the effects of that. And in a manner of speaking, they achieved that. And that was enough. That was enough to start off saying, can we do some experimentation? And thankfully, we have trainee clinical scientists, and I could pull together kind of a volunteer and not use any of the trust's resource that they've invested in me to look at our other risks. And we started to look at how we can actually achieve this. And with a particular configuration, we managed to get these results. And what you can see is where there are grey bands, here, that's where we turned our solution on. And the signal you can see is a perfusion index. It's a measure of the blood flow in the fingertips. And you can see we got quite a marked decrease in blood flow when we wanted to. And from an engineering perspective, once you have that step response, you know that you can actually control things quite precisely using feedback circuitry. And so that was enough. At that point, the moment we saw this result, that was when we started to think about, right, we know it's possible. We know that it can be optimized, and we know no one is doing this. And that at that point, it was time to come and speak to Tas. So I mean, that's where we got to with that. And I don't know, Tas, if you've got any questions on that. That's pretty much that got us to the point of thinking about IP.
No, that's great, Didi. Thank you so much for taking us through that. I've just got my eye on the time. In the interest of time, if we could maybe just go to Debra for her to do her slides, to her part, and then I will come back to questions for you as well, specifically, Didi. Would that be okay?
Absolutely, no problem at all.
Hi there. Hi, so I'm Debra Guest. I'm the Senior Innovation Consultant with CITI. Thanks for the introduction. I'm here to talk about the Tydeman Tube, which is a product I'm helping to get through to market. I actually used to work in the same team as Tas, so I was in the commercial innovation team as a senior IP and commercial research manager for several years, and I've been involved with this project for several years, actually as long as I've been at the trust. It started when I was introduced to a obstetric consultant and general all-round inventor called Graham Tydeman, and he had been working closely with our consultant midwife, who at the time Professor Annette Briley, and Professor of Obstetrics Andy Shannon, who and he worked very closely with them, and he had this great idea, and he sort of started chatting to us about how we might be able to make it a reality. So that's what I'll talk you through about now. The product is called the Tydeman Tube. I'm not sure if you can sort of see on the screen. I have one here with me. It's a single-use device. It's a class 1 medical device, and it's to help with a product called it's to help with a problem called impacted fetal head. So impacted fetal head is a complication that can happen during emergency caesarean sections where there has been an attempt to deliver the baby vaginally, and for one reason or another, things have had to move to an emergency caesarean section. But in the process of that baby sort of almost being delivered vaginally, the baby's head becomes deeply impacted into the mother's pelvis, such that when the incision is made for the caesarean section, it can be very difficult for the obstetrician to deliver the baby. And so in this instance, very often the first thing the obstetrician will have to do is to try harder, which isn't a great thing to be wanting to be doing in this situation. They're going to ask an assistant, usually a midwife, to push up with their fingertips from the vagina. This is something we know midwives really don't like doing. They don't know where their fingertips are pushing. You know, the baby's head could be looking up, it could be going to an eye, and pretty awful outcomes have occurred as a result of impacted fetal head. So we know it's associated with damage to both the mother and the baby. There's some data from 2019 in the UK where over 6 months, looking at just 82% of hospitals with obstetric units, 13 babies were shown to have sustained severe injury or died as a result of impacted fetal head, and 2 of those babies that died was directly as a result of impacted fetal head. So this is a significant problem. We know that in that same study of 6 months, over 550 cases where the team reported difficulty releasing the baby's head during delivery. We think this is the tip of the iceberg, because those were the really bad cases. We think that actually the incidence of this is higher. In the UK, we're looking at over 5,000 instances per year, based on our sort of estimations, which, you know, across the world is probably looking at around 1 million cases per year. Although we do accept the fact that obviously incidences are very different in different countries, because different caesarean section rates and practices and so on. So the device that's been invented is called the Tydeman Tube. It's serving to do 2 things. On the one hand, it's looking to push up on the baby's head during the caesarean section when elevation is needed, and it can be used just only when it's needed. So only if a problem is encountered, they can insert this Tydeman Tube. And it's really replacing that idea of the midwife pushing with their fingers. And that means that the elevation can be controlled, the force is dissipated over a sort of soft silicone cup onto the baby's head. And then the second thing that can happen is that Graham Tydeman will always describe a kind of slurping noise, like a welly being pulled out of mud, when they do finally manage to release the baby's head, and also a feeling of air rushing over his fingertips when they manage to get the baby's head out of the uterus. So this they believe is because of a vacuum effect that's been built up. And the Tydeman tube has a hollow tube that runs through it to enable air to come in and release that vacuum. So we managed to get we supported the team to get some funding, and they were able to try this out on a simulator, which I'll mention briefly later. They got some really great data with the simulator, and then were able to use it on a limited number of women at Guy's and St Thomas's, with all due sort of governance and processes put in place, and it was well received. And there's also been some patient engagement work done which shows that it's acceptable to women. And then obviously the story begins about how do we get this to market. So I wanted to just for a moment sort of dwell on it. It's probably obvious, but why commercialisation? You know, and I think it's clear to say that with a medical device, this isn't something that we can take to market or that we can get into practice at Guy's and St Thomas's on our own. And if we'd gone through the trouble to get it in at Guy's and St Thomas's, it would be pretty crazy to not try and make it available more widely. And so then we have to look at a commercialisation route, because really Guy's and St Thomas's isn't in the business of regulatory approvals, manufacturing, marketing, sales. That's not what we're here for. And it makes a lot more sense to work with a partner who that is their business. So the regulatory processes I've been very much involved with for the last 2 years. It's a long slog. It's a lot of hard work. And obviously the responsibility and liability coming back to the legal manufacturer needs to be considered. And there's a lot of money that needs to go in to get all these things in place before you can start placing a medical device on the market. So we would look at a commercialisation route to make this a reality. And then we have really, as Tas has touched upon, 2 options, a licensing or spin out option. So we're currently in the processes of trying to find a licensing partner, for the main reason that this is a really great product for licensing. There are companies out there who sell in the obstetric space who can just take on this product and sell it alongside their other products, and it really is the most sort of straightforward way to get something to market. We had considered a spin-out option prior to 2019 when this data was collected. Actually, this problem was really poorly recognised. People didn't think it was a big issue. They thought it was super rare and not something that would be worth the investment of getting a product to market. That's really changed in the last couple of years. And so we're looking to secure a license deal. We're in negotiations at the moment. And obviously, as part of that, we're looking to make sure we get a fair financial return back to the trust and the inventors. So one of the things we were obviously very keen to do was make sure our IP was adequately protected. We have registered designs on the Tydeman tube. We also have a trademark on the name Tydeman. And we have a patent which has been granted in the UK, across Europe, United States and Australia, which we consider to be our key territories. So this is something worth explaining, is that once we'd put in our patent application a few years later, we come to this national phase where we're asked, well, where do you want to have patent protection? It's not, or you don't have such a thing as a worldwide patent. And so we had to really carefully think at which areas might we want patent protection and which areas are we prepared to pay for that patent protection. So we opted for the areas where we think there'll be the best markets and where patent protection would be important to our licensing partner. So the key thing here, as Tas touched on, so our patent actually is getting quite old now. We really need to be getting a move on with our commercialisation, because we're incurring costs every year. So every year that granted patent needs a renewal, we're having to pay renewal costs. We've spent over £35,000 on that patent to date. If you compare that with our trademark and our registered designs, these are in the region of less than £1,000. So patents are expensive, and if you want them to be covering different geographical regions, they can get very expensive. So having that commercial strategy in place when you file that patent is really, really important. What we've found is that in the commercial discussions we're having with potential licensing partners, it pretty much is the very first question they're asking. So we tell them about our product. If you want to Google it, there's a lovely video on YouTube about the Tydeman Tube from Andy Shannon. And the very first question is, well, what's your patent protection? So we're able to tell them, yes, we have a granted patent in all your key territories, and they are very, very happy. Why are they doing that? Well, they need that reassurance. They need that reassurance that they're going to protect their investment in spending money to get this to market. They also need the reassurance that they're not going to be disadvantaged, because we're doing a license agreement, you're going to have to pay us a royalty. Obviously, if someone else can get a competitive product to market without having to pay a royalty to us, then that company would be severely disadvantaged. So it's a really key question that we get asked, pretty much is the first thing. Something that's come up with our discussions around the Tydeman Tube is really interesting. What happens after the patent expires? And so the patent protection lasts for 20 years. That's that monopoly that having a patent will give yourself or your licensing partner in order to make sure that you protect that investment that goes into getting it to market. After that, the company would argue that the royalties should reduce, or perhaps not even have any royalties left to pay, because at that point it's effectively on the open market. So this is where we hope that our other forms of intellectual property protection, such as our trademark, will come to play. And I just wanted to wrap up by talking about the Desperate Debra, which is actually a simulator for the problem of impacted fetal head. So going back several years to when Graham first had his idea for the Tydeman Tube, he was on the train to Guy's at Thomas's to meet with Annette and Andy, and he was thinking, I need a way of testing this. Well, he had already sort of got this testing rig in place to try and test out the Tydeman Tube preclinically. And on the train, on the way to meet everybody, he suddenly realised, wow, hang on a minute, this is an excellent training simulator. Prior to that point, there was no way of training for impacted fetal head before you first experience it in the theatre. So this not being a medical device, as a training simulator, not a medical device, has been much quicker to get to market. We were able to find a licensing partner quite quickly with Adam Rury. Again, there's a lovely YouTube video on YouTube of Graham talking about the Desperate Debra training simulator. So the training simulator is for impacted fetal head. It's licensed by Adam Rury. It's been on the market for quite a few years now. And we do hope, and the important thing is that this does not have patent protection, but is quite successfully licensed and quite successfully sold. That was a decision that we took in discussion with our licensing partner, and this is quite a specific product. It doesn't have a huge number of sales, it's something you reuse over and over again, and they look at the size of the market and the chances of somebody bringing along a competitor product and felt that putting a patent on this would not be appropriate, and I completely agree. It's not a good candidate for patents. So if you'd have looked at how much we would have spent on patent protection over the years, does it justify what it is you're trying to protect against? And if the answer is no, then maybe a patent isn't the right way to go. It does have a registered trademark, so nobody can come along and try and make something similar, call it Desperate Debra. And just to wrap up is the fact that obviously once the Tydeman Tube does get to market, then this Desperate Debra training simulator will be an excellent way for people to practice using the Tydeman Tube in a simulator environment. So the two innovations will come nicely back together. Thank you.
Thank you, Deborah. Thank you for that. Only just a couple of points to add to what Deborah's just said. One is that the two examples that she's shown. The first one was there just to illustrate that you need to be thinking about more than one type of IP with any one idea. The patent may be a start, but you do need to think about other types of protecting, other ways of protecting the IP as if it's appropriate. So there may be a patent, a trademark, a design right around something. So that was to illustrate that. And also the second one, very much so that it is the commercial strategy drives whether you need a patent or not. That's key. There are situations certainly where you don't need a patent. Now I've noticed we don't have a lot of time. There's only 5 minutes left to go. There are a couple of questions, if that mainly for Didi, but Deborah, do please comment because you were involved in Didi's project too. Firstly, Didi, you've been through the patenting process. one, you know, having done that, what are your thoughts on the process itself? I mean, how do you feel about having filed? I think it's the first patent that you have filed. So how do you feel about that particular patent? What is that work was done, that job was done?
I'd say for one thing that it was actually really exciting, because this is definitely something from a child. I've wanted to be a designer and to invent things, and you could argue my team designs and invents things all the time, but not quite in this way. So it was really sort of gratifying and rewarding, but also there's kind of a wave of obligation, because now you've kind of protected that launch pad for you to do something with it. Now you've got that duty to do something with it, which is, I think, a really good thing. We don't want ideas to kind of sit and languish. And I saw there was in the chat, in the question, there's a question around, do we know how many things are kind of fail or don't make it through at some stage? And I think there's a kind of an untold story there, and this is one of those things that can actually boost something from being just an idea, and give it a bit of momentum towards hopefully having that impact.
No, I mean, that's an interesting point in terms of, from everything that I've read, people with an entrepreneurial mindset, they often have experiences in their early childhood, or when they're much younger, which stimulates that entrepreneurial spirit. And it's interesting, you mentioned that in design expression was important to you, from very early stages, and I guess that must have to some extent molded an entrepreneurial mindset.
Yeah, I'd say so. I think that I definitely wouldn't have called it entrepreneurial, and then I think sometimes the idea of commercialisation and entrepreneurship in healthcare can feel like they're at odds with each other. But from my perspective, it's always been about the impact, and what you come to realise is, for anything to have impact on this scale, for an idea to have impact on this scale, it needs to be sustainable, and therefore it needs the business model, therefore it needs the IP. So the sooner you start thinking about it, the better.
Yeah, that's great. I've just noticed there's a message saying that we do have more time for questions, so it's okay. We've got more than 5 minutes. Didi, in going through that process, if there were 3 in the patenting process, if there were 3 key points that you perhaps learned that you think would be of benefit to others in sort of remembering as they may go through a similar process, what would they be? 3 or 4 key points that you think were learning points for you, or things that you think were critical in that process.
I think following a good design process helped in hindsight. I think that by first of all really focusing on what the problem is and understanding, and the things that we didn't necessarily show in the slides is the amount of exploration and discussions and thinking in a kind of a structured way to understand what the requirements are was key, because then when it came to the IP protection, it's you then know exactly what's inventive and impactful, what those headlines that need to be captured within the patent. So I think one of them is following a good design process that is kind of first led with the problem, and then also have your rationale. So whenever you come up with an idea and it's good, why is it good? And record that, because that's the sort of stuff that gets played back to you, and it's very helpful to be able to pull it out of notes that you've made, and those notes that you made help you to have more ideas as well. So I'd say follow a good design process, starting with a problem, and document things as you go. The third point I'd say is, it's what you'd said, be very careful about the way you share things, and be very deliberate in that. And that changes drastically once the patent is filed, or when you go into the process, when you want to be extremely open with the patent consultant and with colleagues in CITI who are going to help you through it all.
Yeah, well, no, that's great. Thank you, Didi. And I guess also just to stress to people listening, this is really just the start of a very long process. Once you file a patent, it's a long way. It can be 3 or 4 years before you're even granted. It goes through a very expensive and sort of strong examination process, and the patent examiner will come back with all sorts of reasons why they can't grant you a patent, and then you have to work with patent attorneys to overcome those objections. So it is an arduous process getting to a point where you're filing something that's worth filing, but then that really is just the beginning as well, just to say that a very long process. Debra, I can also bring you in as well. Are there points that you would like to add as well in terms of what's been said in the patenting process from your experience, for examples that you've worked on too?
In terms of important things that have come out of the patenting process?
Important things, or things for consideration from your point of view as well when going through a patenting or IP protection process. Are there things that you would emphasize too as well?
Yeah, I think really interesting to hear what Didi says. I think obviously, you know, that is always that thing about the keeping of the notes and sharing them, you know, sort of being able to pull them back out to understand what the inventive process is. And I think that the inventive step thing is what people tend to find a challenge, you know, to really go through it. But I did all of this work and say, okay, but that's not inventive. What's the inventive bit, and what can go in to make those claims in your patent? So I think that's usually the bit that quite often takes the thinking. And obviously that can be very interesting when you have a team of people who have been working on an invention, is to try and pull out which of those steps were the inventive steps.
Yeah. It is. In any examination of a patent, it is the inventive step, whether it's inventive or not, that usually the objections are around. As I briefly mentioned, its novelty is usually easy to demonstrate, whether something's been invented in the past or not, but it's whether it was an obvious step, that inventive step, an obvious step for the person skilled in the art. That's where often the objections and the difficulties come in the patenting process. Happy to also take questions from the audience at this stage as well, if there are people who have a specific question. Happy to take that as well.
We've got a question from the audience. So one of the questions is, so you mentioned about what are you licensing if there is no patent?
All right. So a patent is only one form of IP. You can patent know-how. You can patent any of the other forms of IP that I mentioned at the beginning. A patent is only the most obvious one. So copyright material, design rights, know-how, and often know-how and patents go together. When you license a patent, it can go hand in hand with licensing some relevant know-how as well. So all of those are licensable materials, not just patents. Yeah.
I think there's another one too. This may be for Debra as well, about what is the value that can be placed on some of the non-inventive inputs that you mentioned?
Yeah, so I think Tas has touched on this already. So, you know, the inventive step is what's really important for the patenting process. But obviously, you know, we could think about sort of putting in designs that maybe wouldn't be considered inventive, but you can still, I mean, you know, designs can be protected with unregistered designs, which is an automatic form of protection, as well as registered designs. You know, a trademark wouldn't be an inventive step, but is arguably something that is quite powerful in the right hands. So just to relate back to that last question, in the case of the Tydeman Tube, you know, if the company chooses to carry on using the name Tydeman Tube, and you know, then has 15 years or so of marketing it as the Tydeman Tube, there's value in that, even after the patent has then expired. You know, if another company comes along and starts creating something, once the patent's expired, they can't call that the Tydeman Tube. So the brand, the awareness, you know, the business has already been built up around something that's fallen off the back of that product. We, you know, as I say, with Desperate Debra, that's been licensed basically on sort of, you know, the designs and the plans and the know-how that went into how that simulator would be made. So then it's discussion with the company around, you know, sort of this is how we think you need to make this, and that's what goes into the license. So you can license, you know, as Tas says, other forms of IP and know-how, which is quite an intangible thing to be able to say that you'd be able to put it into a license agreement. It is something that you are giving somebody that you own, that you are giving somebody else permission to use under certain terms and conditions.
Yeah, and I just wanted to add to that. There are ways of modelling, of putting a value to the intangibles. They do involve judgment in terms of quantifying, making actual quantifications, but there are models to help you do that, and we can refer to those. But whatever it is, I guess the important thing is getting something out there that has impact that we want to achieve, and if we guess what we consider is an acceptable return to us, you know, then generally that's fine. And one other thing I would probably add as well is that the best form of dissemination quite often in getting things out there in terms of having an impact is to commercialize them. It's rather than perhaps giving them away free or doing it some other way, which might be a little bit counterintuitive to some people. But commercialization can actually get the dissemination done in many cases more effectively than any other way, because it then obviously, you know, there's an organization then proactively distributing and selling the item. So just another point to emphasize. Is there is there time for other questions that we can cover in the time?
Yeah, we've briefly got 5 more minutes of our allotted time. So there's one more, I think, maybe for Debra, about, so it says Debra is the tube used within the trust, which Debra alluded to, but wanted probably a bit more information about the impact. And it'd be great to understand both on a personal level, but also on the numbers and metrics, if there's any impact numbers that can be shared.
Yeah, thanks. So we're not currently able to use the Tydeman Tube at the trust. It's a Class 1 medical device, so its previous use was under a particular route that we were allowed to use it back then, but now that it's in this sort of pathway towards commercialisation, we don't have permission to use it anymore. So we now have very clear instructions from the MHRA that we have to wait until it has its UKCA mark before it can be brought into practice at the trust. So obviously one of the reasons we are keen to get this going. I saw Didi come off mute. Is there something you wanted to add there?
Yeah, I think it just ties into Tas's point as well. And there are other cases, other inventions that we collaborate on. You know, the 3 of us now, that others have come up with, where in order to get over these kind of regulatory barriers, it needs to have sustainable funding, and this is why you can't get around commercialization, because doing it for free also means that it can run out of steam. It needs that kind of a commercial engine to keep it going, and keep it going very well. So yeah, just those 2 points tied quite nicely together.
Yeah, thanks Didi. In terms of impact, I mean, you know, obviously once this is on the market, we believe that it will have a huge impact on the lives of babies and mothers. So, you know, mothers can be injured as well. We know there's a psychological angle. We know that psychologically, you know, if there's often obviously more than one parent in the room when a baby is being born by caesarean section, and we know that both parents, both the parent having the baby and sort of anyone else in the room, can be impacted with you know, trauma by what they're experiencing, and in a process of sort of an emergency situation, if there's a product that the team can turn to help with that emergency situation, the whole thing can hopefully be handled in a much calmer way, which will have then a mental health impact. We know that the midwives who are being asked to push up on the babies really hate this, so hopefully it will help with them in their sort of roles. You know, as I say, we think that this will be able to be used globally. We are reaching out to companies specifically who are able to take this as far and wide as possible. So we do hope that this is something that will have a far-reaching impact. For me personally, I mean, you know, the opportunity to be involved in a project, and then this has been a long ongoing project, and to really be able to see it all the way through, and to think that it can be on the market, being sold, and helping sort of save lives, is huge. So it's got a huge personal angle for me as well. And just to add to all of that, the other thing that comes out of this, and we don't like to talk about this occasion maybe, but you know, these babies who are harmed at birth due to impacted fetal head, they very often have, they can have, well, very often, but they can have severe brain damage. These are babies who would have the biggest, highest payouts from NHS resolutions in the UK and other sort of obviously bodies overseas. You know, we know that of the NHS resolutions payouts, or claims I should say, 1 in 10 relates to obstetrics, but 50% of the budget goes to obstetrics. Because if a baby is brain damaged at birth, then obviously, rightly, they're going to need an awfully big payout. So if we can help that, then there's obviously an impact there for sort of litigation budgets as well.
Thank you, Deborah. That's really good. Aidan, in it got a couple of minutes.
So we've got a final question. It's really good to hear Deborah's reflection on that. So the final question is, patent applications you mentioned are a time-consuming process. Markets may change, technology may overtake. Is there any protection granted in the meantime?
The protection only comes into effect once you've filed it. For example, a UK priority patent. Before then, it's best to keep everything confidential. But once you've filed what is known as a UK priority filing, which can then be internationalized later, based on the original UK filing, that's the key date. It's the date that you file. Yeah, I mean, it's quite kind of black and white. There is no protection until you file that, except keeping it confidential. I mean, keeping something confidential just as know-how is actually also a form of protection. You could, and some companies actually do decide not to file things and keep them completely confidential as a form of protection. Yeah, so that's what I would say on this. Deborah, would you want to say anything extra on that?
No, I think you covered it really nicely. Thanks.
Yeah, hence the importance of, I would say, hence the importance of having NDAs in place, confidentiality agreements, if you need conversations with companies beforehand. Again, only giving them the minimum information. That's all because, you know, if we are looking to file a patent, then protection is not there until we actually file it. Okay. And one other point, just to I guess finish on, the second seminar in July in this IP series is going to focus specifically on patents in detail, in a lot more detail. I will have a patent attorney on that particular webinar too. So just to mention that.
Cool. Thank you, Tas. Do you want to close us down for the evening? Yeah.
So, you know, thank you everybody for attending. I hope it was useful, and we hope you can attend the second and the third of these, which are in July and August. The July one will look specifically at patents, as I mentioned, and the final third one in August will look at other forms of IP in a lot more detail. Okay.